What an enthusiastic welcome, thank you. My name is Nicola Allsop. I am a barrister at Quadrant Chambers. I've practiced in commercial law, including civil fraud, for over 15 years, and I have particular experience in interim remedies. This QBiT talk is about Norwich Pharmacal Orders, or NPOs, as we like to call them. I'm going to answer 4 questions during the course of this 10-minute talk. 1, what is an NPO? 2, when might I need one? 3, how can I get one? And 4, what should I be aware of when considering whether or not to apply for one, and indeed applying for one? So moving straight on to what is an NPO? Well, it's a disclosure order, but it's a special disclosure order. And that's because it's not made against the defendant to proceedings. Rather, it's made against a third-party respondent. What's a third-party respondent, I hear you go. Thanks. So, a third-party respondent is not the ultimate wrongdoer. He's not going to be the defendant when you come to issue proceedings. Rather, he's someone who, through no fault of his own, has got caught up in some wrongdoing. He's not going to incur any personal liability, but he comes under an obligation to assist the victim by giving the victim full information. Now, that may include disclosing the identity of the wrongdoer, which is obviously key. It's a flexible remedy. An NPO can be obtained pre-action, during the course of an action, and even post-judgment. Post-judgment particularly important in terms of enforcing that judgment. However, it's settled that it cannot be used as part of a mere fishing expedition. So, when might I need one? Well, NPOs are particularly useful in fraud cases, and that's where my experience of them mostly stems from. But they're not limited to such cases. At Norwich Pharmacal, the case itself was a patent infringement case. As I've said before, they can be used to obtain the identity of a potential defendant to proceedings. They can also be used to locate assets upon which a judgment may be enforced, and to obtain information which is central to the contemplated claim. How can I get one? Thank you for asking. I'm going to answer this question in 2 stages. Number 1, I'm going to talk about the test for obtaining an NPO, and secondly, I'm going to look at the procedure. The threefold test is well established. First, a wrong must have been carried out, or arguably carried out, by an ultimate wrongdoer. Well, what does a wrong mean in this context? It's afforded a rather wide meaning. It may be a crime, it may be tort, breach of contract, equitable wrong, or even a contempt of court, which is capable of being identified in general terms. So the applicant at this stage doesn't need to be able to plead a case regarding the wrong. He just needs to be able to prove it in terms of a good arguable case. That's the threshold we're talking about. The test for establishing a wrong is a good arguable case, which mirrors that, of course, in a freezing injunction. Second limb of the test, there must be the need for an order to enable action to be brought against the ultimate wrongdoer. An NPO is not a remedy of last resort, but it will be refused, or will likely be refused, where the information could be obtained by alternative means. And here the most likely candidate is an application for pre-action disclosure under Rule 31.16. The third limb, the person against whom the order is sought must be mixed up in the wrongdoing and able or likely to be able to provide the information necessary to sue the ultimate wrongdoer. What do we mean by mixed up with? Well, this is often referred to as the mere witness or bystander rule. A mere witness or a bystander is not a suitable Norwich Pharmacal respondent. It must be somebody who's done more than that, not necessarily facilitated the wrong, but has been mixed up in it such that it takes him beyond being a mere witness. An example of somebody who would just be a mere witness is a bystander who's written down the details of a hit-and-run accident. He's done nothing more than simply witnessed it, and therefore Norwich Pharmacal relief is not going to be granted against him. Even where those 3 limbs are met, the Norwich Pharmacal is an equitable remedy. So the court will then go on to exercise its discretion. It will only grant the order where it's necessary and proportionate in all the circumstances. But it is available to assist any vindication of rights, and so it need not be made in the context of anticipated litigation. It can be made to support a form of self-help or disciplinary proceedings, for example. It really is quite a wide and flexible remedy. The CPR doesn't identify the specific procedure for seeking an NPO. If the application is sought before the issue of proceedings, it's going to be by way of a claim form, and more likely the Part 8 procedure than the Part 7 procedure. However, if the application is sought after the issue of substantive proceedings, then you can follow the application notice procedure in Part 23. It can be made without notice or on very short informal notice where there is a need for secrecy or urgency. Probably not going to be that common to make an application for an NPO without notice because, of course, the respondent against whom the order is sought is more likely than not a victim in all this. Worth saying a bit, though, at this stage about applying for an NPO against a bank. In my experience, banks rarely oppose the making of an NPO. So with that in mind, an applicant is well advised before making the application to write to the bank. Don't at that stage identify the bank account or the holder of the bank account, but simply explain to the bank what you're going to do and ask the bank if they are going to oppose or not. Generally, banks will not oppose, they'll write a letter to that effect, and that letter can then be placed before the court at a relevant hearing, and it makes everyone's life much easier. However, the bank does need that order to comply, because otherwise it's going to potentially put itself in breach of duty to its customer. Now, the documents in support of an NPO application. I've already spoken about the claim form or the application notice, but what other documents are needed? Well, at least 3 other documents. First, the evidence in support. This can be detailed in a witness statement, not necessary to use an affidavit as we have to do in an application for freezing injunction. Third, a skeleton argument, normally drafted by counsel. That skeleton argument is going to outline the key facts, the test for an NPO and why that test is met in the circumstances of that case. And thirdly, the draft order. Now, the draft order is a key document in an NPO application. It needs to set out with care and clearly the documents or categories of documents or information which is sought from the respondent, and also the time frame within which the respondent must provide those documents or information. Consideration should be given as to whether or not a penal notice is attached to the draft order. Now, if you're going against a bank, you probably don't want to include a penal notice. You don't want to be too aggressive. You don't want to put the bank off. But if it's not a bank or an institution, you might consider including a penal notice, which will make committal proceedings in the event that there's non-compliance easier at a later stage. And with that point in mind, serving the NPO personally is a good idea if you're concerned about non-compliance. Finally, the order might include a gagging provision. Now, that's a provision restraining the respondent for a specified period of time from informing anyone about the application or about the fact that the information needs to be provided. Really useful tool, and banks quite often like the comfort of a gagging order because it means that they don't risk breaching their agreement with their customer. I'm just going to finish with some points to be aware of on a Norwich Pharmacal application. 5 points. First, the duty to give full and frank disclosure if it's made without notice. Second, applicant is normally ordered to pay the respondent's legal costs and, in fact, the costs of providing the disclosure, but these can be recovered in the claim against the ultimate wrongdoer. Third, the applicant will be required to give undertakings, and in particular undertaking damages. Fourth, the respondent may be able to refuse to provide the information on the basis of privilege against self-incrimination. And finally, in accordance with the general rule under CPR 31, the information disclosed can only be used for the purpose of the proceedings in which it is obtained or the anticipated proceedings without the consent of the owner of the information or permission from the court. I'm going to leave you with those 5 points. Thank you very much for listening.